Do you understand? I don't have to follow that. I could sentence you all the way up to the maximum possible penalty.
It's somewhere just south of $30,000 worth of arrears.
In cases like this, there wouldn't be any wheeling or dealing. You would have to come up with a lot of cash and you would still go to.
What you just watched, that was the judge finally losing her patience. Bronson Fischer claims he's doing his best, but there is a $30,000 hole in his story that he simply cannot explain. What you saw was a man at the end of his rope, but you haven't seen the decade of choices that led him here. This is the state versus Bronson Fischer. On the surface, it's about missed child support, but it's really about the weight of a decade of total financial silence. Fischer, a professional artist and businessman, sat in court today facing a potential 7 years in prison. Why did he only register a legal address once he was finally behind bars? And how does a parent let debt hit $30,000 while his daughters grow up? The timeline just doesn't add up. If you want to understand courtroom psychology and how the legal system catches those who try to disappear, hit subscribe for more breakdowns. Let's see how this unfolded from day one.
We will go on the record in the matter 23 CF 186 and 187, State of Wisconsin versus Bronson Fischer. The state appears through Assistant District Attorney Jose Vila in person. We have Bronson Fischer in person in custody with his counsel, Emma Hanu. We're set for a plea and sentencing. Ms. Hanu, can you please recite the agreement for the record?
Thank you, Your Honor. In this case, Mr. Fischer would be pleading to count 2 in both 23 CF 186 and 187. And just so the court knows, it's count 2 because in 23 CF 186, the first count is outside of time limits, and rather than have him plead to a count that is outside of time limits, count 2 for both, for simplicity of the court, for a withheld sentence in exchange for 5 years of probation, 140 days, 5 days of conditional jail for time served. A stipulation to the amount in arrears and a condition of probation would include restoring payments to child support and getting set up with that upon release. In addition, the state would agree to uncharged, dismiss and read in count any uncharged failure to support accounts from the time of initial charging to today.
So count 1 in 23 CF 186 is dismissed outright.
Yes, it appears to be that way, Your Honor.
Granted to dismiss count 1 outright in 23 CF 186. Mr. Fischer, before I begin, are you still on Kruger Road A?
No, that's my old address.
Do you have an updated address?
Yes, I actually got one registered finally just while I was in here to the property that I'm staying in Minnesota.
And what address is that?
It's 7088 Mallard Road, and that's Brook Park, Minnesota.
Brook Park?
Yep.
Do you know the zip code?
I believe it's 55007.
And will you have a telephone number?
Yes, I do.
Is it the 3650?
No,
What is the number?
that's 715-600-1128.
May we send you text message notifications?
Yes.
Okay, so I have in front of me an electronic version of a plea questionnaire waiver of rights form with attached jury instructions. Do you see that in front of you on your attorney's computer?
Yes, I do.
Is that the document she went over with you?
Yes.
Is that your signature on the second page?
Yes, it is.
Did she thoroughly go over the document with you, essentially word for word?
Yes, she did.
And you understood everything completely?
Yes, I did.
You were pleading guilty to 2 counts of failing to support. Is that correct?
Yes.
That is count 2 in both cases. You're 44 years old. You have 12 years of schooling. You can read, write, and you understand the English language. No drugs, alcohol, or other medications in the last 24 hours, and no mental illnesses or disorders, correct?
That is correct.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page. Do you understand those rights?
Yes, I do.
Did your attorney thoroughly go over those rights with you?
Yes.
Do you need me to go over those rights with you in any more detail?
No, I don't think that's necessary.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes.
Do you understand you're pleading guilty to felonies? As such, you will no longer be able to use or possess a firearm for life.
Yes, I understand.
You'll no longer be able to vote in any election until your civil rights are restored.
Yes.
Do you understand that here the state would have to prove for 2 counts, but we'll go count in 23 CF 186, count 2, the state would have to prove on or between November 1st, 2012 through February 28th, 2013 in Burnett County, Wisconsin, you intentionally failed to provide child support for at least 120 consecutive days where you knew you were legally obligated to pay said support. Do you understand what the state would have to prove?
Yes, I do.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or 3.5 years of incarceration or both?
Yes.
Do you understand in 23 CF 187, the state would have to prove as to count 2, failing to support that on or between January 1st, 2018 and April 30th, 2018 in Burnett County, Wisconsin, you intentionally failed to provide child support for at least 120 consecutive days where you knew you were legally obligated to pay said support. Do you understand what the state would have to prove?
Yes, I do.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or no more than 3.5 years of incarceration or both?
Yes.
Do you understand that the agreement between the parties is for 5 years of probation for 145 days of conditional jail as a time served and certain conditions while on probation? Do you understand I don't have to follow that?
Yes, I do.
Said differently, I could sentence you all the way up to the maximum possible penalty if I thought it was warranted, and I could do so today.
I understand.
Do you understand I could also sentence you to what's called a withheld sentence or an imposed but stayed sentence?
Yes.
Do you understand the difference? I can
Not
explain it.
super, the imposed and the withheld sentence.
Correct.
I'm not exactly sure what the difference is,
The
but
difference is if I place you on probation and I give you what's called a withheld sentence, it means that the entire time hangs over your head, 3.5 years for one charge and 3.5 years for another charge. And I can, at that time, if you're revoked, sentence you to the maximum penalty for both, either concurrently together or consecutively, one at a time. Do you understand that?
yes.
Imposed and stayed means that the court could say today, I'm going to sentence you to 3.5 years of incarceration for each, but I'm going to have you do it concurrently. And I'm going to stay that. And while you're on probation, you do what you need to do. But if you're revoked, you will not come back to court because I won't need to sentence you. You'll just go sit that 3.5 years. Do you now understand the difference?
Yes, I do.
All right. And do you understand that it's my discretion in what I sentence?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over both of the criminal complaints with your attorney, in particular, those sections called the probable cause sections, where it basically says what happened during those periods of time and why you were charged with these crimes?
Yes.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you admitting here today that you in fact are guilty of failing to pay child support at least 2 times where it's been over 120 consecutive days?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Do you have any questions for the court or your attorney before I proceed?
I don't believe I have any questions.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No.
You're doing so freely and intelligently, telling the court that you fully understand what you're doing here today
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has she answered all of your questions?
Yep.
Has she looked at these matters thoroughly?
Yes, she has.
Has she discussed with you a potential for any legal defenses or a lack of defenses in these cases?
Yes.
Has she discussed with you the evidence and the discovery that she's received in these cases?
Yes.
Have you discussed with her your facts as you know them to exist during these periods of time?
Yes,
Have you discussed with her your thoughts on whether or not you have any defenses or a lack of defenses?
yes,
Are you satisfied with her services?
yes.
Do you have any questions for the court or for your attorney before I proceed?
I do not.
As to count 2 and 23 CF 186, failing to support a child 120 plus consecutive days, and I felony, how do you wish to plead?
I plead guilty.
As to 23 CF 187, count 2, failing to support a child 120 plus days consecutively, and I felony, how do you wish to plead?
I plead guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of counts 2 in both cases. The remaining, as we stated in 23 CF 186, count 1, that's dismissed outright. The remaining counts in that case will be dismissed and read in. The remaining counts in 23 CF 187 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. I think the joint recommendation here is appropriate. To my knowledge, Mr. Fisher doesn't have any felony convictions prior to today, so he's walking away with his first pair of convictions on a felony matter. I think this sentence needs to accomplish the goal of having a big enough hammer to deter Mr. Fisher from re-engaging in that problematic behavior of not wanting to support his child, specifically deterring him from doing that and generally deterring the public from not paying their court-ordered child support. There is a victim in this case, it's his child, and as a result, she has not received support for a number of years. And I don't have the updated number here, but it's somewhere just south of $30,000 worth of arrears. That's a lot of support that she's missing out. I think 5 years of supervision should be enough of a amount of time to keep him on the straight and narrow to make sure that he continues to support his child. Should he fail to do so, he faces revocation and potentially a prison sentence. With that, I would ask the court to adopt. Thank you.
Thank you. Ms. Hanu?
Thank you, Your Honor. I would agree. I believe that this recommendation is appropriate. If the court remembers Mr. Fisher's first appearance here, he was going to plead guilty to every count, not speak to an attorney. The court did advise him rightfully to get an attorney. Since then, Mr. Fisher has remained steadfast that he does want to take responsibility for this. He's doing that here today by walking away with 2 felony convictions for a period of probation that would require him to start to pay. The court is not overly familiar with Mr. Fisher. He's not a resident of Burnett County. So I'd love to tell you about him. Mr. Fisher is a business owner. He creates art, I believe, and does some carpentry and is a generally good person who does want to take responsibility and is here to do that. And I think by giving Mr. Fisher the opportunity to now get out of jail, he's been sitting here since November to get back to his business, to his home, to start getting on track with child support, does the public and does Mr. Fisher and does the court significantly more good than keeping him in jail or prison. ADA Vila is right. There is a victim in this case. That's Mr. Fisher's child. The goal with failure to pay charges is getting somebody back on track, is getting that support. I think this agreement does just that. I would note that Mr. Fisher does have 165 days of credit. This was for 145 days of conditional jail. As of April 8th, obviously, we had to set this out to a sentencing hearing, but I would ask the court to adopt this recommendation.
All right, thank you. Mr. Fisher, is there anything that you would like to add, you would like the court to be aware of about your situation and about this case?
I really just I know I messed up. I just don't plan on getting in that situation anymore. I just want to try to keep on doing the best I can to abide by the law and pay off the rest of what I have to pay. So.
All right. How old is your child? I'm trying to find it. This didn't
I
originate from
I
here.
actually have 2 children.
Oh, are we dealing with 2 separate ones? I know
Yes,
LMS.
186 and 187. There's one for each child.
Okay, and so how old are your children?
My oldest daughter is 21 years old. And my youngest daughter is 15.
All right. All right, Mr. Fisher, this is serious well, first the court has to look at how serious is this matter. Then I have to look at you, your history, what you're telling me about yourself, your employment, your age, your education, those things. And then I have to look at needing to protect the public. This is serious in the fact that we're dealing with two children who have not been supported by you for a significant period of time. And if we look at these cases, at least from 2009 on, however, that 2009 can't be included because it's too old. And so that's why that one was dismissed. But it's been a significant period of time where the children have not been supported by you, and they've needed to be supported by their mothers. And hopefully, at least it may only be the financial aspect where you've fallen short. Hopefully, you've been there as a parent and you're there to be there as an emotional support for your children, because your children do need you. Even if they are 15 and 21, they still do need their father. But financially speaking, you did create the children. You have an obligation to support the children. And hopefully this is going to get you on track, and to do that because you could actually go to prison for failing to support. I do think that probation is appropriate. And so what I am going to do is I'm only going to order 4 years of probation. Either you're going to do it or you're not, but I think 4 years is plenty of time to be on probation. I'm going to order 165 days of jail, of conditional jail. That's time served. You have 165 days of credit. So that's what the court is going to order. I'm doing an imposed and stayed prison sentence. Here's why. Because this is seriously important that you support your children, even though one is already age of majority. It didn't mean that she didn't need to be supported and that the mother didn't need that extra financial support in order to raise that child. And so what the court is going to do is, in sentencing, I have to look at other factors too in sentencing, and a length of sentence. I have to look at deterrence, not only specific deterrence to deter you from continuing to fail to support or to pay your arrears that is owed, but also general deterrence. So others, mothers and fathers who are obligated to pay support, know that they have to pay that support, and they will be deterred because they don't want to go to prison as well. I do make mention of my very close friend, Sarah in Michigan, in the Michigan Attorney General's office, where I served with her. She is head of child support over there, and she is great at her job. And I'm going to tell you, in cases like this, there wouldn't be any wheeling or dealing. You would have to come up with a lot of cash and you would still go to prison. She has prosecuted actors and professional athletes and all of that, plus average day folks who fail to support. And I'm going to tell you, over there, child support, failing to pay child support is far more serious than I have noticed or seen over here in Wisconsin. So what the court is going to do is, if you are revoked off of your probation, the court is going to order 1.5 years of prison with 2 years of initial confinement. And that is going to be a concurrent sentence for both. You are going to be ordered to pay your monthly child support amount plus the arrearage amount, and you must do so timely every month. You are ordered to have gainful employment, and that means that if you're not cutting it and paying the bills, doing your artistry and all of those other things, you have to get another job to not only, well, first and foremost, to pay the amounts that you are owed to pay monthly, but also to support yourself. The court is going to dismiss pursuant to the agreement, any uncharged failing to pay support from date of charging here until present, until today's date and time. And so you're going to start anew. The court is going to give you, I'm going to say, I don't know where you are with regards to your child support, et cetera, or where they are in collecting, but I'm going to give you 1 month before you have to start and getting your payments and getting them paid, because it's going to be difficult, I believe, once you're released to be able to come up with the money right away. So your first payment is going to be due for both of these cases and the child support in June. Okay, so that gives you over a month to get at least stable enough to make those payments. You have 20 days to appeal. Failing to pay within 20 days means you will lose that right. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. Again, 165 days of jail credit. I have no indication that I need to do an absolute sobriety, but you are going to be on probation. And you are going to be in probation in Minnesota. So this is an imposed and stayed sentence. So you're going to need to, Mr. Fischer, get out, hit it hard, get money, make your payments and make them timely, because otherwise you're going to just come back here. Child support will drag you back here. And plus that'll have consequences on your probation because you're ordered to pay. Fines and fees and court costs, the court is going to, I'm going to order $518 for the first felony, $250 for the second felony, waiving court costs and fees. That is going to need to be paid separately from your child support. And honestly, you're going to be paying this court, not probation. So you're going to send payments for the amounts due here, not to through probation.
Yep.
And the reason I'm doing that is because then I get to see if you're making the payments with regards to your fines and fees. And if you don't, the court will issue a warrant and you could sit up to 6 months outside of any of that other time, because the court is ordering that even though they're concurrent together, 23 CF 187 and 23 CF 186 are concurrent together in serving any time, they will be consecutive to any other sentence you may receive in any other case or jurisdiction. Okay. So minimum monthly payments, I'm going to say, I guess I don't know. Are any of you aware of what his monthly payments are going to be for child support?
My understanding is they're going to have to restart it.
Well, the last time it was set at $200 per case. So that was $400 a month. And part of that was going towards arrears in addition to the child support payments for each case.
Okay, so right now, I'm going to accept a minimum of $50 a month to be paid to Burnett County for your fines and fees on top of the amount you're going to owe for child support. Okay, so if by chance you're having a hardship and you can't pay your fines and fees at $50 a month, you have to let me know and I have to have a hearing with you and figure it out. And I'm going to tell you at that time, I'll probably throw in a child support hearing. But I'm going to guess child support is going to be figuring things out with you, and you're going to be working and talking with Burnett County Child Support. But $50 a month for your fines and fees, again, to be paid to the Burnett County clerks here, and not to probation. I believe that covers everything. We went over address, telephone number, all of those things. Report to probation immediately after you are released. Your DNA will be taken. You may be able to request it be expunged through the system through a written letter to the Department of Justice, not to this court, to the Department of Justice. Easy to do. Google it, or Ms. Hanu can help you. Mr. Vila, what is the court missing?
I don't think you're missing anything, Your Honor.
Ms. Hanu?
Nothing, Your Honor. Thank you.
All right. Good luck to you, Mr. Fischer.
Thank you.
Thank you. We are adjourned.
The decision is final. Bronson Fischer avoids jail today, but that prison sentence is still hanging right over his head. But here's the question. Was this ruling fair or too lenient for a $30,000 debt? Comment below, Team Fisher or Team Prosecution? Does he deserve a chance to work and pay, or should he be behind bars? If this case got you thinking about the reality of the legal system, hit like. Share this with your true crime friends.